Family trusts are like motor vehicles. They go out of date and need to be cleaned up every so often. Every time Labor gets in or Liberals get in, they generally will change policies and what have you, and you may well need to update the family trust. If you have a family trust over 5, 6 or 7 years old, it probably needs a clean up of the deed. Now, you can see here that there are 4 different types of updates to a family trust that you can do on our Australian law firm website. So you can just update the trustee, there's a training video on that. You can update God, the appointor, succession planning, there's a training video on that. You want to update the deed itself, there's a training video on that. But today, we're going to do the everything update. We're going to update the deed, the appointor and trustee, and it is our recommended document that you use to build up family trust updates, because it rights all wrongs. It fixes up a whole lot of different issues, even issues you don't know about, it will fix up. So you can see that you could also build other things, an annual distribution minute, you'll get that with this update. You can do a vesting deed, which winds up the trust. You can change the name of the family trust. But today we're going to build the everything update, which will allow us to clean up this entire family trust deed for both appointor, trustee and the deed itself. As with all our documents, there's a full sample, and you see that the first thing you will get when you update any of our documents or build a company as trustee of a family trust or whatever you're doing, whatever you're building, you always get a covering letter from us confirming that we author the document on our law firm's letterhead, signed by a partner of the law firm. There's a trust opinion certificate which the banks will want if you're ever going to borrow money from a bank, so that's all there for you. There's the minutes and there's the deed itself. Now that's a sample. Obviously when you build your document it will look different depending on how you've answered the questions. There's a full checklist of the questions to be asked, so your accountant or advisor, or you may well just go straight online and build it yourself. There's a training video, and also with all our introduction pages to each of our documents, there's about 380 documents you can build on our law firm's website. There's explanations before you even start the process, but all these will be explained as we go through the document. Let us begin. Let us draft a family trust deed of variation in order to update your family trust deed for the deed itself, the appointor, which is God, and trustee, which is just the puppet. Now, I have built many documents over many years, and I could pick up the data from any of those documents. But in this instance, I'll just use or start the document from fresh without any of the information. So the first thing is your family trust will have a name. It's a made-up name, it's a nickname. So the most common family trust name is the Smith Family Trust, because Smith is a very common name in Australia, much to the accountant's dislike, because family trust names shouldn't be too replicated, but they are. So in this case, I'm going to call it the Smith and Weston Family Trust. Now the word "the" is already in the document, so don't worry about whether your family trust has the word "the" or not in it. We rectify that, we fix that up for you. Now I can't find the family trust name, so maybe you're looking through the deed, you can't find the family trust name. Then have a look over here at the hints. Where do I find the trust name? There's a training video just on that one issue of how to find the family trust name. Every family trust has a name, it's a nickname, so it just goes through all those answers. What about, I'm a bit worried, I've heard this thing called resettlements, and if you do fiddle around with a trust, you could resettle it, which causes capital gains tax and stamp duty issues. Our covering letter will confirm there's no resettlement issues in this document. Our law firm's letterhead, it will contain that information on our law firm's letter. So I've got the name, I found the name, it was in the last couple of pages of the family trustee. The word "and" was lowercase. Now the date of the original deed. Now my family trust has been amended 6 times, but we're only after the original trustee that set up the family trust. So look, it'll either be on the very last page or very first page, will have a date. If it's, what's that? Your family trust deed is undated. Not as, it's more common than people realise. Now let's see if we've got a hint. I can't find the date of the trust deed. Another hint there. My trust deed is undated. We've been preparing up deeds of variation since 1988. Every time we're asked a question, we'll answer it in these hints. So if you've got a question that's never been asked before, just chat to us or email us or telephone us and we'll be happy to answer the question. So if it's undated, then what do? You put in the date it was stamped, if it was stamped, or you put in the date, which is the closest to the date when the family trust was started. So in this instance, family trust was started in 2002. It's been updated many times, but it was originally started on the 17th of July 2002. I've got a green tick. A green tick means our law firm is satisfied that the logic flow. So I'm now going to go to the next question, which is the set law. Now, so you've got the set law, you've got the trustee, you've got the appointor. The set law is just the person that put the first $10 or some small nominal amount into the family trust to prime it, just to get it going, to prime it. And you never see them again. You never see them again because the set law, sadly, cannot be a beneficiary of your trust. And a family trust is 3, 4, 500,000 beneficiaries. It's not just the 38,000 registered charities in Australia. It's not just if you've got a share in BHP and BHP's got 500,000 shareholders. They're all beneficiaries. It's not just distant beneficiary, not distant relatives you've never met in Italy or America or England or Indonesia. It's everyone. The class of beneficiaries is as wide as possible. When your son gets married, his wife will become a beneficiary of your trust. It's meant to be as Catholic and as large as possible. But the set law is someone you probably don't like your lawyer, accountant or advisor that set the first $10 in. I'm just joking. How could you not love your lawyer and your accountant and financial advisor? So the set law here was actually my accountant, John Shepherd, who has sadly passed on. And his last address before he was dead was in the ACT, and that's the set law. He's dead, but I've still got to put him in. It's only to identify the family trust. And if you want help and advice on why we ask that question, there's a hint and yet another training video for you. And if you can't be bothered watching the training video, just telephone us. We'll answer the question for you. I've got another green tick. I'm doing well so far. Now, the appointor is leaving. So currently, the appointor might be my dead father, could be my dead wife or whatever. They'll be leaving. But in this case, no one's died, so no one's leaving. Staying is me. I'm a human. And so I'm staying, but I'm also putting my wife because my wife's a high-risk person. She's a partner in a professional services business, and I'm a stay-at-home dad. So she's high risk of insolvency. Traditionally, you would not make her the appointor because she's should be a person of straw, and I'm the stay-at-home dad, and I'm a man of substance. But our family trust deeds are drafted so that if one of us, as the appointor, suffers an insolvency event, dies, becomes of unsound mind, we're immediately taken out as the appointors, immediately taken out. So in this instance, I'm going to add my wife as co-appointer with me, so the two of us are there. So when I die, we'll have, she will be the remaining appointor, and vice versa. Now, backup appointors. So let's get this very clear. The trustee looks like it's an important entity because it's got the assets in the name of the trustee, often a company. I'm going to say this one thing. If you get nothing out of this training video, just remember this one thing. And if you know this, you know more than most lawyers know. The appointor in a family trust is God. It is in full control, unfettered control. The second entity, the trustee, is a squashed cabbage leaf. It has no power. It can be sacked without reason or rhyme. It can be dismissed by God the appointor. So if I make you the trustee of my family trust, I then tell you to distribute to my wife and my children. If you say no as the trustee, I'll merely sack you and put someone else in control. So appointor is God. So the trustee, I don't care who the trustee is. I don't care who the directors of the corporate trustee are. I'm really interested, particularly for succession planning, who is the power? And that's the appointor. Now, in my family trust, the appointor is my wife and myself. But I'm now going to have a backup appointor. Now, some people say, oh, Professor Davies, I've made it my legal personal representative, which is the executor named in your will. That's wrong. I know a lot of people have done that, but it's wrong. You should not allow your beautiful, unchallengeable family trust to be corrupted by a grubby little document called a will. The people that can challenge a will are, it's not just your parents, your people you sleep with, like your wife and mistress and gay partner. It's not just your children you adopt and stepchildren. It's not just all your grandkids. It's also in other jurisdictions, such as New South Wales and Victoria. There's a whole raft of other people that can potentially challenge your will. Don't let your family trust be corrupted by putting succession planning for the family trust in the will. Don't do it. Take advantage of the deed of variation and put the appointors on. Now, I want my appointors to be my two children. Commonly, it will be a company which my wife and I will have shares in. That's been very, very effective succession planning. But at the moment, I will just go with my two children. And another backup appointor. So now, when I die, my wife's the remaining appointor and she's in command. Once we're both dead, the backup appointors will take over, not the will. It's not the person named in the will. It's just ridiculous to put succession planning in a will. It's stupid. And if you've got legal person representative as your backup appointors, it's wrong. So now, upon the death of myself and my wife, it's our two children. Trustee leaving? Yes. So the trustee was me. I no longer want to be the trustee. If obviously there's no change of trustees, just trustee leaving, you'd answer no. But I don't want to be the trustee of my family trust anymore. My accountant's advised me there's some asset protection issues, and I agree with the accountant. So I'm leaving, and the trustee's saying is no one's staying, and the new trustee will be a company. So I've incorporated a new company as trustee of a family trust, which you can do on our website. So you can actually build a company as to be trustee of a family trust, which is another training video. But I've got A, B, C, ABN nominees. It's a bit confusing. A, B, C nominees. PTY Ltd. Rather interesting spelling there, but that's the way the company's called. And that will be the new trustee. I'm coming off, that's going in. Now, obviously, if you're not changing anything, you'd have answered accordingly. Now, interestingly, I've got green ticks for everything but trustee leaving. the law firm is not happy with how I've answered the trustee leaving. And that angers me. I'm angry that that law firm, Legal Consolidated, is telling me what I can and cannot do. I want a green tick to be there, but there's no green tick. Let me be very clear. Legal Consolidated Barristers and Solicitors is responsible for this document. We are your lawyers preparing this document. We control the complete logic flow of the document. You'll get this document as a locked PDF. We do not want you to change it. We want you to follow the logic flow as we're responsible for it. That's why we do it. There's a tightness regarding the way we do your documents on our website, which is critically important. So let's have a look at why I didn't get a green tick. So, well, it looks good to me. I'm just going to press next. Whoops, there it is. I haven't put in the surname. Clarkson, there we go. Now I'm going to press next. Yay, I've got a green tick. So yeah, I shouldn't be too angry with the law firm requiring tight logic. I do want my document to be legally binding. I've now finished the document. Look at that. I'm really happy with that. I can rechange the name of the document if I wanted to. This is just a lot of the users of our law firm's website are other lawyers, accountants and advisors. They might have 400 or 500 documents they've built over the last 20 odd years, and they'll want to put in different categories for different clients, so they can go back in 20 years ago and say, what family trust update did we do? What wills did we do? But I'm happy to just leave it to family trust. As an accountant or financial advisor or lawyer, I could add my corporate logo. I could select to remove the Legal Consolidated logo from the document, but only if you're a lawyer, consider doing that. I could select the box for a print behind and post. I've got my own printer, I'm okay with that. And I could have a lawyer telephone me. I don't need that. So I'm now going to press next. Now watch what happens. At the moment, you do not see lock and build. You do not see lock and build because we're not happy yet. So let's see, we're going to press next. And there it is. You will see lock and build because we are happy with the document's logic flow. But now, this is a summary page, you've got an opportunity to check the spelling. So, yes, that looks all fine. John Shepherd. Oh, John Shepherd's got a middle name. Colin. There he is, Colin. Are the appointors staying? Yes. Backup appointors are the two children. Trustee new, because I'm going to flick over. No, look, I'll tell you what, I'm going to put the new corporate trustee in. I've done it. Now I'm going to press lock and build. I'm going to put in my credit card details. Success! I have built my deed of variation of my family trust, and I can now access my documents. Also been emailed to me. I can save it onto my hard drive. I can email it to someone to print out and sign and do whatever I want to do. It's my document. It is a locked PDF. If you do need to change it, just email us. We'll give you a voucher so you can make any changes you want to it. So here it is. It's as a PDF and it's opened up. Now the first thing you see is the law firm's letterhead confirming what we have provided to you. Our law firm, Legal Consolidated Barristers and Solicitors, has provided this document to you. Thank you for instructing us to prepare the attached family trust, appointor, trustee and deed update. How to print it. All the changes, so the latest changes that have been made, the streaming provisions, the ATO's latest rulings on that. The franking credits, the attribution rules have gone in. The new extension of the capital gains tax regime. Majority of appointors take all trusts over minorities. Now this is interesting. Faulty family trust deeds. Trustees that are wrong will state that the majority of appointors, remember the appointors are God, can override the minority. So, Professor Davies, I've got 3 children and I'm going to make them all, my wife and I are going to make them all appointors after my wife and I are dead. And they need some rules there, so I'd rather have it so that majority rules. No, you can't do that, because the two of the children, if they had majority rule, could take 100% of the assets. Oh, Professor Davis, they love each other. They all wouldn't do that. Well, I don't know what they're going to do when the family court or the bankruptcy court and what have you gets involved. You have to act unanimously. Oh, but what if they fight or they can't agree? Well, then you go to court. That's the nature of a family trust. The appointors have to act together. Otherwise, the minority gets slaughtered and they end up with no assets. The definition of net income, critically important if you don't want to upset the ATO, if you want to keep the ATO happy, this is the definition they prefer under Bamford's case. Asset preservation, asset protection, such an critically important issue for our modern Australian culture of everyone suing each other. Family trusts are very effective in protecting your assets. If the appointor is dead, then it explains how the legal personal representative or how the next of kin will sign. The trust opinion certificate is for the bank, so that you can get loans if ever required. Now, interestingly, a trust opinion certificate can cost $800-900 from your lawyer. You've got that as part of the service for the family trust update. That alone is highly valuable. Minutes. Resolution of the trustees, just confirming that this deed has been accepted by the family trust, and here it is. Law firm letterhead. The outgoing trustee was Clarkson, the new trustee was the nominees, the remaining appointer was myself, and the new appointer will be my wife. So now we've got two appointers, my wife and myself. I'm coming off as the trustee for asset protection purposes, maybe, whatever reason, my own private reason why I came off as trustee. The new trustees, the company, the remaining appointors, the backup appointors. When all the other appointors, and quite often your family trustee might use an expression other than appointors, such as guardian, principal, nominations, or similar controlling words or definitions, then the backup appointors will be child 1 and my younger child, Mary Lou, and they'll be the backup appointors upon my wife and myself dying. All the new rules have gone in. The trustees' powers have been augmented. The trustees' powers have been increased to comply with the new rules. Additional powers to borrow and lend, which is required by the 4 major banks in Australia. Well, what they currently want. 4 or 5 years' time, they might want something different. There's no partnership clause, is very important. Some family trustees, in fact, a family trustee I'm reviewing at the moment is drafted in a way where it's potentially the appointors are in partnership with the trustee. That's exactly what you don't want. When the family trust collapses and goes insolvent, the only one that goes down with the sinking ship is the trustee, not the appointors. The appointors are gods. They need to be protected. And therefore there should be a clause, and just check your family trustee to make sure there's a no partnership clause, such as the one you can see there. Reducing stamp duty and capital gains tax, ensuring there's no resettlement, signed by the parties. And there it is. You've done a deed of variation of your family trust in order to update everything in it. The deed, the appointors and the trustees. Now, if you need a hand building this document, or your accountant advisor or lawyer's building this document, they can telephone us for free. And as a law firm, we can give legal advice to help you answer the questions. Enjoy this wonderful document.